Good evening, everyone. I am CA Amita Vissa, moderator of the webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be a moderator in webinar on Succession Planning Essentials, Tools and Tactics on 25th September, that is today, from 2 p.m. to 4 p.m., being organized by Committee on Commercial Law, Economic Advisory, and NPO Cooperatives of ICAI. In a short while, we'll start the webinar. I would like to apprise you about CCLEA and NPO Committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial law, economic advisories, and PO cooperatives. Today's session is designed to equip members with practical insight into succession planning, a subject of growing relevance in both professional advisory and family business contexts. We are honored to have with us CAO, our eminent speaker for the day. He is a chartered accountant associated with KC Mehta and Company LLP, KCM, where he leads the succession planning and transaction vertical. His work span is designing and drafting wills, trust, and succession structures, advising promoters, families, and groups, particularly in Indian family-owned companies, both listed and unlisted, supporting tax and FEMA planning for wealth and business succession, publishing thought leadership through KCM Heirloom, and contributing to platforms like Tax Sutra and FCI Bulletin. He has been a speaker at prestigious forums, including ICI and Chamber of Tax Consultants, and bring a wealth of experience and clarity to this domain. We look forward to an engaging and enriching session. Without further ado, I now invite CAU to take us through the topic, Succession Planning Essentials, Tools and Tactics. Over to you.
Yeah. Screen is visible, right?
Yes, visible.
Yeah. So, good afternoon, friends. Thank you to Amita ji, thank you, Mayank ji, for inviting me, and especially thank you to the Committee on Corporate Laws, Commercial Laws, Economic Advisory, and NPO Cooperative of ICAI. Friends, before we start, I would also like to thank all of you for joining in at this hour on a weekday. It means a lot if our fraternity is engaged in such an inspiring sort of a learning drive where we can spare 2 hours of our earning week in learning something new. And the topic selected is also something praiseworthy, which the committee has done. I think this topic requires more and more deliberation, more and more people in the practice as far as chartered accountants are concerned. So, without any further ado, I would just like to begin with the session. The topic for today is succession planning essentials, tools, and tactics. What I plan to cover today is I'll start by taking every one of us through why would you go for succession planning in the first place? How is it important? How is it relevant? And thereafter walking through each of the instruments of succession which are in place, and some softer features of succession planning as well, which we'll go through during the session. So most of my time would be spent in analyzing each instrument from a succession planning perspective, including tax and regulatory aspects. but more focused on the commercial realities. Now, so as I said, why succession planning? So before tackling that aspect, we'll just address as to what is succession planning as far as we are concerned. So when we say succession planning, it's not something of a HR domain. We are talking about deciding at present as to who will be the successor in terms of the owner as well as the controller of the property or the wealth which we are talking about. So it could be a business where we are talking about who would take over the business after XYZ person is no more. Or we would also be considering a case where it would be a real estate asset which would be taken over, let's say, by or inherited by the next generation. And the considerations would differ largely. So, succession planning, as far as we are concerned, would be including two aspects. One would be economic succession planning, is what we call it. That is talking about smooth transfer of ownership more than anything else. So, transfer of ownership from one generation to the other generation should be in a manner where there is least amount of friction involved, so the next generation can inherit it peacefully and go about their business without any hindrance in their day-to-day life. For example, there could be title clearance issues which you would be addressing during your life, so the next generation has less troubles to face. Then there is management succession. The other aspect, the management succession aspect, is about smooth transition in leadership and management. So consider a case where a family business has become a business started by one person, has become over a period of time a family business, and the next generation, possibly your cousins, etc., your brothers, are also involved in now involved in the business, and there is a real need to decide as to who will be, how will the management or leadership work out after you are no more. So these are the aspects, these are two broad aspects which we try to tackle during the succession planning exercises. So now, having broadly understood as to what we try to achieve by succession planning, what is the relevance of succession planning? So why would you do succession planning in the first place? So for that, friends, we need to understand as to what happens without planned succession. So uh, very simply put, without planned succession, the results are unpredictable. Uh, as we'll also see in the later slides, if there is no succession planning in place, as in there is no will, there is no trust, nothing is in place, then everything belonging to you would be passed on to the next generation or your heirs by virtue of a personal law which applies to you based on the faith you subscribe to. For example, if you are a Hindu, Hindu law would apply. If you are a Muslim, Sharia law would apply. If you are a Parsi, Christian, or Jew, Indian Succession Act would apply in terms of succession where you have done nothing, you have not even written a will. So, and what happens is that ultimately these laws are more or less drafted in order to take care of broader situations, which leads to an issue that our situation would generally be very specific, and these laws have rules which are set in stone, which means that you may want, let's say there are two, one son and one daughter. You may want to give everything to the daughter or everything to the son, or you may want equal distribution. Well, maybe your faith, maybe your personal law would have a rule which is not exactly framed in a manner which you are assuming. So let's say if you are a Hindu, you would think that all my wealth will anyways go to my son only after I die. Well, that is not the case. It would split equally between the son and the daughter. It may so happen. So the results basically are unpredictable. There is also a lack of clarity because most of the personal laws may be uncodified. That is not actually legislated per se by the parliament and taken based on the religious texts, etc., which will also go around shortly. So there is a lack of clarity. There is a possibility of that. There is, and all of this accumulates and results in a highly litigable situation if there is no planned succession. So post your lifetime, maybe you end up causing litigation for the or creating opportunities for litigation for the next generation. Uh, there are also unintended results, as we took up in the earlier example. Maybe you have named your daughter as a nominee. Son gets all the assets under the will. or something of that sort you have mentioned. Maybe you thought that daughter gets this bank account which you have named as nominee, and in the will, you are writing that you have not mentioned the bank account at all, and you have mentioned that any assets which I possess will go to my son. Now, what will happen is, if had you planned for succession and taken some advice, you would have realized that nomination may not override will, and possibly the bank account would also go to the son. And so these are unintended results which may crop up if you don't plan carefully. There is also a case where you have own some foreign assets like a US company share or something like that, and end up incurring a huge foreign estate tax duty, estate tax liability. So these are aspects which need to be considered during the planning itself, and without planning, you may end up incurring these costs, either monetary or non-monetary, as mentioned earlier. Now, family disputes may also arise because of unplanned succession. So, leadership management, as I mentioned earlier, may not be clear, and there may be cases where the family enters into the business, and there are troubles as to who will be taking the decisions pertaining to XYZ things. What happens is family disputes may take precedence over actually running and growing the family business itself. Is detrimental not only to the family but also to the employees of the business and a larger stakeholder group, which planned succession would have helped you tackle effectively. So, friends, these were the very obvious reasons for which succession planning is relevant. Uh, Finally, before ending this, I'll just mention one point, that good planning, it all boils down to good planning and clarity. Because if that is there, then it will always foster family unity, and business growth will be established. So that is basically how succession planning would be relevant. Uh, Now, uh, as I mentioned earlier, what happens if you do nothing at all? So you don't even write a will. Intestate succession, that is all. That is what they call it. So if you write a will, it's called testamentary succession. And if there is no will in place, then it's intestate succession. What happens in intestate succession? So wealth is passed on as per the applicable inheritance personal law. So and how would you decide which personal law applies to you? So that is based on the faith which you subscribe to. For Hindus, Buddhists, Sikhs, and Jains, the Hindu law is applicable. As far as succession is or inheritance is concerned, Hindu Succession Act 1956 would apply, and the provisions therein would dictate as to how the property would pass on. And these are a complicated set of rules. If you look at it, there are class 1 heirs, class 2 heirs. Within class 1 heirs, there is a list. And if the class 1 heirs, let's say point number 1 is son, daughter, wife. If these are found, then the assets will be distributed between these point number 1 heirs equally. If the first point is not found, then second it goes to the second point, then third, then fourth. Once you have exhausted class 1, let's say there is no class 1 heir left, then you go to class 2 heirs. If class 2 heirs are not there, then you go to agnates and cognates. So it's a long list of relations which may get the assets which you have in case it is an intestate succession. And this generally leads to a lot of ambiguity and possibilities of litigation. Then there is also, in case you are a Muslim, let's say, Muslims are subject to Sharia law. Now, Sharia law is completely uncodified as far as India is concerned. However, the application of Sharia law is codified in India. The act is one-page act, the application of Sharia Act, which only says that all Indian Muslims will be subject to Sharia law in India. That is the only line which is mentioned in that act. And Sharia is effectively entirely sourced from Quran and other religious texts which Islam uh, has propounded. So there are around 800 verses within the Quran and other texts which tell you as to how the property should devolve upon the next generation. Uh, and so these are the aspects which you need to keep in mind during intestate succession for Muslims. For Christians and Parsis, Chapter 2 and Chapter 3, Part 5 of Indian Succession Act 1925 uh, are applicable. So in case Christians, Parsis, Jews, etc. Die intestate, then Indian Succession Act would govern their intestate succession. as well. And again, there are detailed rules in this part of the law as well. What it all boils down to, as I also mentioned earlier in the earlier slide, that there is a lack of complete codification, which means that, let's say, even in Hindu Succession Act, I have mentioned that it is codified to some extent since it's a parliamentary act, but most of it remains uncodified, and the part which is uncodified is covered by Vedas, Smritis, Shrutis, and other such religious texts. Then there is another source which would be the judge-made laws. So that is the precedents from various judicial authorities within the country. Uh, and these things often are more or less ambiguous as far as applicability to your specific case is concerned, and would sort of be somewhat conflicting sometimes, because since there are multiple sources, may not be the case that each source has considered the other source and thereafter concluded on the rules. So these aspects are generally where issues may crop up in case you are not planning at all. These are conducive to litigation basically. Lastly, these personal laws develop in line with changing social constructs. So, for example, we recently saw that uh, the triple talaq was abrogated as far as Muslims are concerned. Then there was a 2005 amendment in the Hindu Succession Act where they simply mentioned that Hindu daughters will have the same rights and will be considered in equal respect as the Hindu sons. Now, this led to a big repercussion, and there was a lot of litigation. In fact, as recent as 2020, there was a Supreme Court decision which concluded as to how the amendment has to be interpreted. So, what I'm saying is, and there is also this possibility of a uniform civil code, which we are now considering in this country. It's a good idea, but again, personal law, which is undergoing a huge change, will always lead to litigation. So rather than leaving things to chance, it is always a good idea to plan for it. So we are not stuck with this line, a famous line which Ambrose Pierce, an American journalist, mentioned, that death is not the end. There remains the litigation over it. So we may try to avoid somewhat of falling in that category by doing appropriate succession planning. So now, having understood the repercussions of not doing succession planning, of what is succession planning and why it is necessary, we'll now go to as to what are the good elements of a succession. So what are the elements of a good succession plan? First, ensure you are not left high and dry during your life. So let's say there is a person who has a lot of wealth in his own name and wants to transfer it to the next generation. Generally, what happens is, when discussing these things, people get emotional and tend to bequeath, instead of bequeathing everything, they tend to transfer it today itself. They say, "अरे यार, if I have a property today, why not basically transfer it to my next generation today itself, rather than waiting for after my lifetime? It will also be clear during my lifetime itself as to what happens to the property, and there are lower chances of litigation, if any. They will obviously take care of me." These are the thoughts which they have. Now, if you are left high and dry, maybe you are effectively looking at a situation where you will have to, in case you want to, let's say, purchase a car or a house or anything of that sort, you may have to go to your children to ask for money. Now, that is not a good idea to consider during a planning exercise, whether it be succession or otherwise. So this is a concern which we as chartered accountants should point out to our clients in case they are getting too emotional with their succession plan, to keep something, retain something for themselves, and to ensure that they have sufficient cash flows flowing to them regularly. Uh, then there is this idea of bias and sentiments, as I mentioned earlier, also in planning. So one has to constantly try to avoid getting too biased to one of the heirs or too sentimental about the planning exercise. Because it may so happen that during at one point of time you may be favoring one person, and in future you may be favoring another person. And if you have, let's say, you have written a will saying that I'll bequeath most of the property which I have to X person because today is treating me well. Possibly down the line, if you forget to amend the will, the person, if he has started treating you negatively, uh, maybe unnecessarily bequeath with a lot of wealth. And this is a crude example, but this is the sort of thing which does happen, even though it sounds completely illogical at times. So, as chartered accountants, again, our role would be, or as advisors to these people, our role would be to ensure that these things take a back seat, bias and sentiments, and we as third-party individuals can properly assess it objectively as to what they are trying to achieve by doing XYZ things today or maybe in the future, to ensure that their succession plan gets executed. So we can advise them accordingly. Then there is a requirement, obviously, of proper documentation and clarity. So if there is no proper documentation as to the plan that you're doing, so let's say if you are thinking of bequeathing XYZ asset to one of your children instead of one of your five children, then it would be a good idea to expressly mention in your will as to why the other four are left out of the will. And maybe you have endowed them during your lifetime, well endowed them during your lifetime, and they are financially stable, whereas this one person is not as good with the finances as the other four are. So these proper documentation, precision, clarity, all these things are very important. There is on the precision aspect, there is also one thing that sometimes what happens is, in a will you would write that I have five properties, and out of those five, three of these properties would go to one daughter, and two of the other properties and the remaining properties would go to the other daughter. Now we have not mentioned as to which property would go to which property would go to which daughter, and there could be disputes or acrimony post your lifetime as to I want X property, not Y property, and so on. So these are the aspects which need to be considered during documentation as well. And proper documentation is obviously a key ingredient as far as succession planning is concerned. Incorporating flexibility, friends, this is a big one. So if there is a possibility for you to incorporate flexibility in your plan, you might as well use that opportunity to a limited extent, if not a more liberal extent. Because what happens is there are laws are continuously changing in India and elsewhere as well. So let's say India, a common example for this would be India introducing estate duty again, or that sort of a thing happening. You would want that your structure is flexible enough to adapt to this introduction of or change in the new law. There could also be a case where a contingency will befall on the family, and you have kept assets in such a manner that they can be accessed only to a limited extent. And maybe there's a medical emergency, there's a educational need, etc. And the family is unable to access these funds. So this is also one aspect which needs to be kept in mind, that you must incorporate flexibility in your succession plan. And the most important aspect, I think, which is often forgotten, as far as you know, when you think about succession plan, is you must consider not only death but also incapacity. So there was a recent case of in case of Sandhya Anil Kumar from Karnataka High Court, where what happened was that uh, Mr. Anil, who was he was a doctor. So Dr. Anil fell ill, and this was an unusual ailment, which for which he had to be admitted to the hospital. Initially, he was fully aware of what is happening around him, and after a few days or weeks, he went into a comatose state. And during this comatose state, obviously, he was not dead. Now, since he was not dead, although he had written a will, and in the will he had named his wife as the sole beneficiary, but the will was useless because he was still alive, although he was incapacitated. Now, since he was incapacitated in comatose state, uh, the wife thought there would be some solace or some recourse under the law to name her as the guardian or that sort of a thing for the funds that the husband possessed. But shockingly, India does not have such a provision in the entire scheme of laws. And so this poor lady had to deal with the banks through the Karnataka High Court. For 9 months, she could not access the funds lying in his husband's bank account because it was a single bank account, not a joint bank account, where all the funds were lying. And the bank said that you are a stranger as far as the bank is concerned. No, the bank was not wrong. Laws in India are a reality. You can't change that. But at least if he had planned by maybe simply adding his wife's name in the joint account, he could have avoided this unfortunate circumstance. Uh, and a simple planning would be either or survivor joint account would make things pretty easier during this state of incapacity. Friends, the basic point which I was trying to drive at was that you must consider not only death but also your incapacity, whether permanent incapacity or temporary incapacity. Uh, and that is possibly one of the most crucial aspects which people tend to miss out when they think of succession plan. And the last part is buy-in from all concerned family members. Now, this again is a key to a good succession plan because what happens is you would be surprised to know that, let's say, someone has planned simply based on a will. They have written a very exhaustive will, taken care of all the five elements above, and it's a brilliantly drafted will, takes care of everything. What happens is after that person is no more, when these successors find the will, it may so happen that they are not aware as to what all properties in total did this person possess. Starting from there, it may end up to such an extent that they would be excluded. There would be people who are totally excluded from the will, and this was done not from ill intention pertaining to that person, but maybe it would be the other way around, that that person would be doing well in his life, in his or her life, and that's why that person was excluded. But it may lead to acrimony, or if not acrimony, at least confusion among the family members. If not confusion, a lack of knowledge among the family members as to the complete facts pertaining to this succession plan or whatever document we are talking about. And so, friends, buy-in from all concerned family members is extremely crucial. So, it is a good practice to, before starting the succession planning exercise, to take these people into confidence, the entire family into confidence. Uh, this will also, in fact, introduce a sort of a fairness in the patriarch's mind, as to, or the wealth owner's mind, as to what if he can't discuss something with his family, which is about to do. Possibly that is something which is unfair, which is about to do. So it introduces an element of fairness into the exercise altogether. So these are the six essential elements of a good succession plan, which need to be kept in mind. Now, the last point, which is again a overarching point for not only for advisors like us, is that we are too generally, even the families may be such, that all of us are too focused on tax as one of the motivators behind using wills, HUFs, etc. But see, it may ultimately end up harming you if you use these instruments for tax planning, because tax planning may require giving up things, may require giving people additional rights, may require creating interest in interest in property for some family member of yours, passing on cash flows, etc. And these things may come and bite you later on. So while tax can obviously be a factor in considering, during your succession planning exercise, it should not be the sole motivating factor around which you prepare your plan. Now, coming to the tools of succession planning. So there are many possibilities of using multiple different types of tools in succession planning. But broadly, these are the five categories which I'll be tackling today in this discussion. So there is Hindu undivided family. There are gifts and family arrangements. There are wills. There are private family trusts or foundations. There are also family constitutions in place. We'll be tackling each of these and discussing them in more or less a good amount of detail. And finally, there are also simpler tools like joint holding power of attorney, nominations, etc., which are commonly known but may be used more in a more efficient manner, uh, if you know, under proper guidance and basis proper planning. And before we move on, it is always the case that one tool cannot solve all the problems or cannot address all the objectives under succession planning. So what will happen is there will always be a combination of tools involved in your succession planning exercise. So starting from HUF. HUF, that is Hindu Undivided Family, is well known among professionals, especially chartered accountants and tax professionals, if not others. So, Hindu Undivided Family is a creature of Hindu law. As I already mentioned, Hindu law is partially codified. And uh, what happens is, under a Hindu Undivided Family, the membership of this HUF is by birth. No other qualifications are required. And why do I say membership? So, as the name suggests, it's a family, and the family owns properties, deals with these properties, etc. As a collective, and there is a fiction which the law has created. So, a Hindu undivided family is a very different kind of a beast with ownership rights and other rights pertaining to properties, which are very different from what we generally understand in personal context. Uh, Having said that, HUF membership, as I mentioned, is by birth, and there are no other qualifications required. Under your succession plan, you may think that, I won't just by virtue of a person being born into my family, induct him to the vast wealth that I have created. You may want meritocracy or that sort of a structure to be in place, that that person should be capable or eligible enough to access a greater chunk of my wealth. But that is not possible as far as HUF concerned. Once the person is born into your family, he or she automatically becomes a member by birth of your HUF. HUF has three types of members. There are Karta, there is a Karta, there is a co-partner, and other than these two, whoever are the members of HUF, we'll call them plain vanilla members of the HUF. Now these people have different kinds of rights. So there is only one Karta in an HUF. The Karta has a right to deal with the property. He's the one who is responsible for dealing with the property, and also he's a custodian of all the property of the HUF. Now Karta is also one of the co-partners, so he also has all the rights which the co-partner has. Uh, and who is the Karta? So Karta is the person who is the head of the family. Generally, this would be a male. In case that male person is not there and there are no other senior male members who are present in the family, the senior most female member would also can now also be considered a karta. Co-partners are so co-partnery is a different kind of right. It's a right pertaining to ownership, and what is their right? So they have a right to demand partition of the HUF at any given point of time. Uh, and in that partition, they would also get a share in the HUF property, as they would have agreed between the members. So that is another kind of a party involved in the HUF structure. Karta, who is a custodian and a dealer of property for the HUF, co-partners who are parties with significant amount of rights, where they can say that, end this HUF and give me whatever property is my share, and let's go our separate ways. That is their right. The third kind of category is neither Karta nor co-partners. These are plain vanilla members of HUF. These members have no rights per se, except in the event where there is a partition which has taken place by virtue of demand, maybe of a co-partner or Karta or etc. Then HUF members have, under law, a right to the HUF assets and the property therein. That's all. So they are basically subject to any co-partner implementing their or exercising their right to demand partition. And once that is exercised, then HUF members can claim their share of property which the HUF has. So these, friends, are the three types of parties involved in HUF. Now, having understood this entire thing, now we'll be able to better understand as to what are the drawbacks of having an HUF in place. We all know the advantage, and the advantage by far has only been more or less that, there is a tax benefit available, and that tax benefit is that you get a an additional basic exemption limit uh, to the HUF itself. So let's say HUF owns properties, and there is rent income flowing to these properties. Through these properties, then the HUF would be earning that income and paying tax on anything which is above 3 lakhs which it has earned. So people generally try to take this benefit by saying that, see, I have my property, I'll get 3 lakh exemption myself. Then there'll be HUF who would be owning some property, it will also get 3 lakh exemption. So I have basically doubled my basic exemption limit. That is that is the only benefit which an HUF allows you uh, from a financial perspective. Now coming to the drawbacks, and these drawbacks are pretty serious if you look at it. So drawbacks include lack of clear title. Now under HUF, as I said, Karta is the person who deals with the property. Co-partners can claim partition at any time, and HUF members have a right, in case they have a partition, to claim a share in the property. But God knows who owns the property. We don't know who owns the property. Now, let's say I have already told you that the HUF owns property, and some buyer comes and buys and inquires for the property. Uh, the buyer purchases the property. Who would sign? Who would be the person dealing in the property from the HUF side? So the Karta would be the person dealing in the property. Now, this property is being alienated from the HUF, that is transferred from the HUF permanently to this third party. The Hindu law allows a Karta to transfer any property in the HUF only in case two conditions are satisfied. Either of these two conditions are satisfied. Either there is a legal necessity of transferring this, which in itself is a ambiguous term. Either there is a legal necessity of transferring this property, or there is a benefit to the estate by virtue of transferring this property, which again is an ambiguous term. So in future, let's say if someone wants to challenge this transfer, saying that this was not either necessitated legally, this was not for the benefit of the estate, the courts have the power to declare this transfer as void. So for the third party buyer, it becomes a very big challenge to have a clear title, have sufficient uh, assurance as to his title being clear when he has purchased the property from a HUF. So this is a big issue which needs to be tackled when you talk about HUFs. Uh, and surprisingly, there are also cases of courts where they have mentioned that if the person is a third party buyer has purchased his property and the transfer is declared void, one would argue that this transfer had taken place in good faith. The third party buyer had purchased it and so on, uh, against the consideration and so on. But what the courts have concluded is that this third party buyer, it was his responsibility or her responsibility to ensure that there was an element of legal necessity which or benefit to the estate when they are purchasing a property from Karta. So think about it. The transferee has to be the person who has to ensure that the title is clear, or the purpose is clear under Hindu law for that Karta, who is not even related to this person. So this is a drawback. This is a significant drawback when talking about HUF from a succession planning perspective. Then there is also a threat of sudden partition. So let's say HUF owns a lot of shares, controlling stake in a company. Now, co-partners, as I said, can demand partition anytime they want to, and the partition has to take place. So what happens is the shares would get divided among the family members, HUF family members. Now, friends, think about it from this perspective. Let's say you enter into a JV. Most of your shares are held through an HUF. And in this joint venture, the third party is contracting with you to, there is a shareholders agreement in place, there is joint venture agreement, which talks about the terms of the joint venture. And suddenly there is a partition which has taken place because one of the co-partners demanded this. How would you manage this? And why would a JV partner, knowing this, enter into a JV with you if most of the shares are owned by HUF? So this is another issue which may arise. In fact, going back to the lack of clear title thing, let's say the transfer has taken place and there is something. So during that transfer, one of the HUF members or one of the co-partners was a minor. A minor son, let's say, was born to the family. And at that point of time, this asset was transferred by the Karta to a third party. Now, everyone was on the same page. The Karta took consents from everyone and from the minor, but obviously the minor is not competent to contract, so his consent doesn't matter. Once the minor turned 18 years of age, he challenged the transfer, stating that I was not consulted at the time when this property was transferred, and I think this transfer should be declared void. And the courts may actually go ahead and do that because legally that son is not incorrect in claiming so. So these are big, big drawbacks which need to be addressed as far as which need to be considered when you are using HUF, even for tax planning purposes. And friends, there are also practical considerations like cross-border issues. So HUF is a concept which is unique to India. Considering the great improvement in mobility in recent times, you would see that people, especially high net worth individuals, are very mobile in terms of their country or residence. So today they may be in India, maybe their children would be in Singapore, USA, UAE, etc. And an HUF being a conglomerate of these people with varying rights across the board would always be looked at from India as an HUF, but from a foreign country perspective, it may not have a parallel per se. So they may treat it as trust, they may treat it as a partnership firm or whatever, but there will never be a clarity pertaining to this structure in the foreign countries. There are also FEMA issues happening. FEMA, while you look at FEMA's definition, Foreign Exchange Management Act, in that, if you look at the definition of person, you will find that Hindu undivided family is named as one of the categories of persons. So FEMA does recognize HUF as a separate person from the individual or the corporate. But what happens about the residential status? So FEMA, if you look at the broader provisions, you will see that FEMA is totally dependent. It starts basically from the fact as to whether you are a resident in India or a non-resident, a person resident outside India. The definition of person resident in India is itself a huge definition, but it only covers or addresses cases of individuals and corporates. It doesn't address the case of HUF. So that is one issue within the country itself as to how HUF would be treated under FEMA. There is another issue as to foreign tax. So let's say foreign jurisdiction, as I mentioned, may not recognize HUF at all. Because India recognizes HUF as a tax unit doesn't mean they would have to recognize it. And there will be always issues as to, I have claimed I have paid tax in India, withholding tax in India, for the purpose of transferring this money to a non-resident. And that non-resident maybe in US, and US doesn't recognize HUF. The US would generally tax it as maybe a trust, maybe a partnership firm, etc. And there will always be a issue in claiming the tax credit. So that's one another issue because the person are not the same, etc. Or they may disregard the HUF altogether and tax it directly in the hands of individuals. So claiming a tax credit itself becomes difficult. And the last point which may come up in cross-border issues is that contribution to an HUF or partition from an HUF may lead to a foreign gift tax instance. So let's say you have properties in HUF owns properties in USA, like a company shares in USA, like let's say a real estate property in USA, etc. And the HUF is partitioned. There may be an instant of gift tax in this case in USA or the other way around that the property is owned by one person and he transfers it to the HUF. Again, the same thing may happen. So bottom line is HUF, while you may think of it as a tax planning device, it is not actually a tax planning device, and you may end up in a big trouble as far as succession planning aspects are concerned. So choose wisely is the advice. Stable structures are preferable when you are thinking about succession planning per se. Uh, so moving on, gifts. Gifts. We'll start with. So why are gifts succession planning instruments? Maybe you generally think of wills. Wills would only get effective after the person is no more. During your lifetime, if you want to transfer something to the person, let's say to ensure that they are financially well endowed before anything happens to you yourself, you want to ensure that you go leaving behind good amount of wealth during your lifetime, ensuring that this person will not suffer brutally after you are no more. That's why generally gifts are used. and this is also possible as far as portfolio investment and liquid wealth is concerned. So gifts are also possible tools of succession planning. What are gifts? So legally speaking, they are inter vivos transfer without consideration. Inter vivos meaning between two living persons. So it is a transfer between two living persons without involving any consideration whatsoever. Gifts can never be revocable, but there is an exception that a conditional gift may be revocable, and we'll come to that later on. So gifts can never be revocable. That is to say that once I've gifted something to X person, that I cannot never say that tomorrow I don't want this property to be with you. It is now my property. I revoke the earlier gift. That is not possible under the law. Even if you have written that in your gift deed, that is not possible. Sorry. Gifts are risky succession tools because you relinquish ownership today itself. So as I said that if the only relevance of having a gift in this presentation is that you may want to endow that person well during your lifetime, ensuring that that person has all the property they need. But they are not to be used as tools for planning all of your assets succession. Because as I mentioned earlier, also you may be left high and dry. So there was a case in Raymond family. The head of the family apparently had gifted most of his shares or controlling stake to his son. And there were some allegations from this person that his son is not treating him well after this gift had happened. So while while these are unfortunate things, gifts it just goes to show that gifts are risky succession tools and have to be used wisely. Gifts of overseas assets may be subject to gift tax, or maybe a gift between two non-residents may also be subject to gift tax, depending on the country or where the asset is located or the person is located. So it could be US, UK, or any such jurisdiction which levies gift tax as such. So gift tax is also something which needs to be considered as far as gifts are concerned. In India itself, you would be subject to income tax because there is a element of gift tax in income tax itself, that is 56 to 10 of the Indian Income Tax Act 1961, which talks about property received without consideration or property received for a consideration which is less than adequate consideration. Unless there are exceptions, obviously, and if you fall under those exceptions, you will not be subject to gift tax. And one of those exceptions is relatives. So if the gift is between relatives as defined by the law itself, then you are free from income tax, even if there is a gift between these two people. And the definition of relative needs to be read very carefully because you may end up in a tax burden in case you mess up there. Obviously, gifts are subject to a levy of stamp duty, but depending on the state, maybe that can be managed. In Gujarat and Maharashtra, for movable properties, it would be 2%, and for removal properties, it would be 4%. But effectively, it would increase to 6%, including registration and additional surcharge, etc. Uh, FEMA also allows gifts, but only in limited circumstances and subject to maybe certain restrictions. So, for example, the restrictions could be that you check non-debt instruments rules 2019 under FEMA, where a resident gifting shares to a non-resident, gifting shares of an Indian company to a non-resident is permitted subject to RBI approval and is only permitted up to a certain extent based on the conditions which are mentioned therein. So this is also something which needs to be considered in a cross-border scenario as far as gifts are concerned. Now coming to the exception about the gifts revocability. Friends, gifts are not revocable under the Indian civil law, but gifts are not revocable subject to simply the donor's wishes. So let's say I am the donor. I say I am gifting this property to Mr. X. And in the gift deed, I mentioned that, but I can, based on my will or wishes, revoke this gift at any given point of time. This is not possible. This is where the civil law would say that this is not possible and the gift itself is void. But conditional gifts are possible. So you can write in your, so had I written that this gift will be revoked in case Mr. X marries before the age of 24, right? And this becomes a valid gift. And in case that person marries before the age of 24, uh, the gift will be reverted back to me, and the asset becomes my asset from that day onwards. So conditional gifts are also something which may be a helpful tool. But practically, if you look at it, so I have also given an example. Uh, if I give 10,000 shares of XYZ Private Limited to my daughter, provided she completes her CA degree. So if she completes CA degree, this gift is activated. If it's not, then it's not. Then it remains with me. Is this a good idea? So depending on the use that you are doing, it may or may not be a good idea. But ultimately, it comes down to this: how would you enforce this gift? If let's say it's the other way around and it's a negative condition which you are imposing, that the example of marrying under the age of 24, that person, let's say, marries at 22, and you want to enforce the revocation of this gift, how would you do that? The only recourse is going to the courts. And that precisely was what we are trying to avoid by virtue of doing this succession exercise. So that is broadly everything about gifts, which is relevant for our discussion today. Coming to family settlement arrangements. So family settlement agreements are agreements between family members settling the distribution of family property among them. So basically, this may be considered as a broad document which lists down as to XYZ property is owned by X person, PQR property is owned by Y person, and so on. Thereafter, it mentions that this property will go to this person, this property will go to this person, and the reason behind doing that would be to ensure that there is harmony and peace of mind in the family itself. So this is on a broad basis, this is the family settlement agreement. I mean, in Indian context, there are no governing laws as far as family settlement agreements are concerned. So there is no Family Settlement Agreement Act or Family Arrangement Act as such. It is wholly judgment. Only case laws govern this entire concept. In fact, it has surprisingly sprung from a case law itself. So, family settlement agreements, although used widely in India, are something which are completely uncodified and wholly judgment. In fact, the fact that they are used widely is also reflected by the recent public instances. If you look at the Gandhi family recently in April 2025, concluded a family settlement agreement. The Gandhi family is basically the Vadilal family. Also, there is a Godrej, the famous case of Godrej family settlement, wherein one branch of family took over some assets, the other branch of family took over some assets. These assets predominantly involved listed and unlisted company shares. This happened in 2024, April 2024, the Godrej family settlement. So these are tools which are not really theoretical. These are tools which are actually being used. And so family settlement agreements are also something which we need to understand properly. I try to touch upon the relevant aspects today. But of course, this is a very, very complicated and thorough and a subject with which we need to be thorough overall. What is the ethos of having a family settlement agreement? So the logic behind introducing this concept itself was that the families desire to resolve differences and disputed claims to buy peace of mind. And for that purpose, a family settlement was entered into, is entered into, and to ensure that there is no disputed claims, etc., or to at least try to avoid these. And this was beautifully put, as I just mentioned, in Kale's case. Kale versus Deputy Commissioner, sorry, Deputy Director of Consolidation, Supreme Court, 1976. Another point which was interesting, which was pointed out by the Calcutta High Court in Dulal Chand Chatterjee's case uh, in 2005, was that a family settlement agreement assumes a precondition of interest or title in the property amongst the family members who are a part of this arrangement. So, as I mentioned that there would be a list of properties which would have been mentioned and who are the current owners of the properties, etc. in the document itself. What these two statements would tell you is that the reason for entering into this family settlement arrangement is to ensure that there are no disputes today, or if any, we are resolving those basis this agreement. And in case that happens tomorrow, we are trying to avoid it today itself by virtue of ensuring that the settlement allows peaceful transition. The other thing which is being said is that a family settlement arrangement or a family settlement agreement assumes a precondition that each of the properties that are mentioned are subject have a or each of the family members mentioned in the family settlement have a pre uh, predetermined interest or predetermined title in the property, irrespective of whether they're legally or sorry, not legally, but irrespective of whether they are actually named as owners or not. So these are the two statements which are very relevant for the purpose of understanding a family settlement agreement. Uh, Having said that, there are many cases which have happened in terms of income tax, in terms of securities laws, etc., which are relevant for our consideration today. So, what would be a tax implication from a for a family settlement agreement? So, let's say the family settlement agreement said that X asset will go to from Mr. A to Mr. B, who are brothers, then or who are brothers, or Mr. A is nephew of Mr. B, etc. This may be maybe subject to a income tax implication under the Income Tax Act. But surprisingly, it has been held that by Madras High Court that under the if any transfer is happening under family settlement agreement, then that does not qualify as a transfer under Section 2 Clause 47 of the Income Tax Act, and therefore there is no capital gains implication in terms of income tax under family settlement arrangement. If that property is moving under the family settlement arrangement or agreement. If for those interested, can refer CIT versus K KAY KR Enterprises 299 ITR 348 Madras High Court. Very interesting case, and list down in detail as to why there is no transfer. The reason is, as I mentioned in the ethos part, that it is an assumption that there is a precondition of interest or title in the property amongst the family members as a part of the arrangement. So there is no transfer happening per se. One party is just ensuring, one party is just consenting to never challenge the rights of the other party to that property. The other point is consideration always exists as far as family settlement agreement is concerned, and it could be anything. So, what the provision or the law says that consideration is in the form of promise that I will not challenge, or the promise to abide by this family settlement agreement against the transfer of property which is taking place, or the movement of property which is taking place under the family settlement agreement. Now, since the consideration exists, can you say there is gift tax? If you look at 56, if you look at the provisions of 56 to 10 of the Income Tax Act, it says that property transferred for a consideration which is less than the fair market value. It talks about adequacy of the consideration, and fair market value is defined. So, how would you determine as to what is the value of this consideration? It's just a promise. So the question arises: is this adequate consideration? That question is yet to be answered. There are arguments to say that is adequate consideration. There are arguments that it is not, but it can be. So generally, it is advisable to structure a family settlement agreement in a manner in which you know you are safe from a tax perspective, irrespective of whether the adequacy of consideration is there or not. And finally, it is also settled law that uh, in a family settlement agreement, the concepts relating to the family cannot extend to company. So there you can't claim that, see, it's a family settlement agreement and this is a family company which is owned by the family 100%. So effectively, this company is also a part of this family. And so we are saying that the company should also be subject to the same treatment as the other members as far as the taxation, etc. is concerned. The Bombay High Court, in the case of BA Mohata Textiles Private Limited, has explicitly covered this scenario, and you can go ahead and read those interested. 397 ITR 616 Bombay High Court 2017 judgment. Okay, having covered tax for the family settlement agreements, we now come to FEMA. So for FEMA, uh, FEMA is a policy law, and a policy law would not look at the equity pertaining to the treatment of people or the family settlements, etc., which are harmonious, etc., which may introduce harmony within the family. They would generally be, or the regulatory authorities would generally be looking at the larger picture, where the India's forex is concerned. So it is advisable, while it is not been tested, it is advisable to ignore family settlement agreements when you're looking at the transaction under FEMA. You just look at the transaction. If it's without consideration, it's a gift, and consider the implications of gift under FEMA. Uh, from a SEBI perspective, so securities law, how would it work? So as far as takeover code is concerned, this is one of the cases where uh, FSA is relevant. Under the takeover code, the requirement is that in case uh, the shareholdings of one party increases beyond 25% in a listed company, then that person whose shareholding went up to 25 to more than 25% has to offer, has to make a public offer, which is called an open offer, where they would have to offer to the other shareholders to buy out 26% additional stake. So they would have to have that much amount of liquidity. Uh, and so uh, in case of a family settlement agreement, you would say that, X person, the son and the nephew, sorry, the nephew and the uncle would exchange shares, etc. Son would transfer everything to his uncle, or the uncle would transfer everything to his son, which happened in Godrej family settlement. And so the question would arise as to, obviously the promoters would be owning more than 25%. If the shares change hands, would it trigger the takeover code? And so the this is the question which arose in two of the cases, in Alchem Laboratories Limited's case, 2017 SEBI order, and NIIT Technologies Limited case, which again 2017 SEBI order, where they had said that, there is a promoter exemption if you look at Regulation 10D of uh, SEBI Takeover Code 2012, where they have mentioned that if there is a transaction inter-se between promoters, then it's outside the purview of SEBI. And even otherwise, SEBI has specifically observed that since this is a family settlement arrangement and it's for the purpose of maintaining harmony, etc., this should be anyways be looked at leniently, uh, in so many words. But obviously, one would not take these risks and simply try to fall under that Regulation 10D exemption. And foreign laws. Now, family settlement agreement may be a concept which is recognized in India, may be recognized in UK, but it is not. It may not be recognized everywhere in the world. And so, in the same manner as India does it. So, foreign laws like US gift tax, US estate tax, UK gift tax, UK estate tax, and so on, would obviously consider a transfer under an FSA also a gift per se, and subject it to tax like any other gift. And so this also needs to be considered when thinking about a family settlement agreement from a cross-border perspective. So friends, this was all I had to talk about family settlement arrangements. Now coming to the most commonly and most popularly used tool of succession planning, that is wills. Sorry. Now, wills I'll be taking in somewhat detail. Uh, so before that, if we have any questions, we can take those, or I'll just move on and we can take those in the end.
Yeah, there are no questions popping up right now. You can continue with the wills.
Yeah, sure. Just a minute. Now, friend, what are wills? So, will is defined under Section 2, Clause H of Indian Succession Act 1925. They say it's a legal declaration. It's a declaration of the intention of the will maker the will maker is technically known as the testator. So it's a legal declaration of the intention of the will maker with respect to his property. He desires to be carried into effect after his death. Now, taking the definition in uh, in a broken manner, so analyzing the definition in detail, we see that it's a legal declaration. Now, what is a legal declaration? So that declaration has to be in compliance with the other provisions pertaining to testamentary succession housed in the Indian Succession Act 1925. So it has to be legal from that perspective. So a minor cannot make a will, and so a minor making a will would be an illegal declaration, whereas a major making a will would be a legal declaration. So that is how we look at this term. It is a legal declaration of the intention of the will maker with respect to the property. So under a will, you will have to necessarily describe how the property is going to be disposed. You cannot mention under a will that your designation as a trustee will go down to your children, etc. A designation cannot be passed on through a will. While you may consider that nominating a person through a will is possible, uh, that's a simple nomination which you may have done. I nominate my son as the trustee. But ultimately, it will be according to trust deed and the provisions of the Indian Trust Act that things would follow through. Similarly, saying simply that trusteeship goes to my son is not possible because it's not property per se. And there have been cases similar to these where it has been held that management designation is not necessarily a property and hence it's not a will itself. So, as I said, it has to be a legal declaration where you have to mention your intention with respect to your property necessarily. And this intention will only be carried out after your death or that person's death. So, one aspect which is extremely important for us to remember is that will is binding only after the person is no more. Till that time, the will is not binding. Uh, will does not come into effect. While it's not even binding, but it does not come into effect. Uh, Asbury's Laws of England also talks about a similar definition for will. It says that will is a declaration in a prescribed manner. A declaration of what? A declaration of the intention of the person who is making it with regard to matters which he wishes to take into effect after, upon, or after his death. So again, the main point here is it's a declaration which will only come into effect or become binding after the person is no more. And so, if it is not binding till the person is no more, you can revoke the will any number of times and during your lifetime. And the last will which you sign would be last and valid will would be the will which will be considered at the time of your death. So that is the next point which I mentioned, that ambulatory till testator's death and can be revoked any number of times. So you can revoke it every week if you want to till you die. Irrevocable upon the testator's demise. So as I mentioned earlier, also from the definition, it is clear that uh, if and when one person is no more, his or her will is frozen and cannot be changed by any person whatsoever. Will can be in any language; it need not be in English, and legally is absolutely unnecessary as far as a will is concerned. Uh, all of these are binding wills. But clarity is always paramount because, as I mentioned, even in the initial part of the session, uh, in succession planning exercises, clarity is something which cannot be compromised because the entire point of it is to ensure harmonious or smooth succession of properties to the next generation. Who can make a will? Every person of a sound mind and who is not a minor can make a will. Sorry. Yeah, every person of sound mind who is not a minor can make a will. Now, some interesting aspects or some interesting cases which have arisen in the past, uh, which I like to just highlight before moving on. So, can a deaf, dumb, or blind person make a will? The answer is yes, they can make a will. The only thing which needs to be considered is, are they capable of understanding what they are writing in the will, what they are bequeathing uh, exactly as to what they are doing with the will. Are they understanding that? If that is the case, then you can do it, even if you are deaf or dumb or blind. But bear in mind that a person is deaf as well as dumb from the date of birth, from his birth itself, is deemed to be an idiot under the law. But this is a rebuttable presumption, which may not necessarily be set in stone. Now, when I say capable of understanding what? So, in Harwood versus Baker, the Privy Council had mentioned that that person must be capable of understanding three things. As to number one, he's giving property and he's giving this property to whom? Number two, he must be able to recollect as to what all properties he possesses and what all properties he's giving away. And number three, claims of the persons who are included in the will or excluded from the will. These are the three things. If the person is capable of understanding, then you would say that he or she has testamentary capacity. That is, a person of sound mind. Next person we'll talk about is a person who is ordinarily insane. Can he make a will? Yes, only during that person's lucid intervals, just like you have in contract law. Can an illiterate person make a will? Yes, but they need to sign the will. Then also they can make a will. Yes, they can make a will. The law suggests that you can add a mark instead of a sign or a signature. A mark could be thumbprint also. And again, the illiterate person needs to be aware of what all things he is giving away, etc., and must be aware of what he is doing with the will. As far as these conditions are satisfied, even a illiterate person can make a will, valid will. Can criminals or persons who have who have committed suicide, make a will? So, friends, surprisingly, this was not permitted in under English law for a very long time. But obviously, these things have changed, and today even criminals and suicide victims are also persons who can make a valid will and go. Sannyasi, this was an interesting point. There was a 2012 Delhi High Court decision where a sannyasi had made a will, and he had obviously a sannyasi is a person who has renounced the worldly pleasure, etc., and has given up his identity which was given by birth and taken up a separate identity, a new life, etc. So, can this person even own property to bequeath it to someone else? The court answered in the positive, saying that just because you are a sannyasi doesn't mean you forsake the ability of or the right to owning or holding property. That is always possible, even if you are a sannyasi. Uh, and this is an interesting case. If someone wants to read. Uh, and so basically, a sannyasi can also make a will. Can an intoxicated or ill person make a will? Again, boils down to the fact if these people are able to comprehend as to what they are doing, uh, they can always make a will. Now, the main question is, when do we check the testamentary capacity? Is it at the time of death that we check it, or is it at the time of making the will? So, obviously, the answer is you check the testamentary capacity or the sound mind and not a minor condition at the time of making the will, and not at the time of death of this person. Uh, Lastly, who can be a legatee? A legatee is the beneficiary basically under the will, to whom the will maker is bequeathing the property. Who can be a legatee? Any person can be a legatee. All you need to have is that person is capable of holding property. It could be a natural person, company, even animals. The only problem with animals is that opening bank accounts, getting demat, getting a PAN in their name, these things would be a pain, and you may not get actually these things for the animals. And so it would be a better idea to set up a trust for animals instead of bequeathing property through a will. But anyways, this could also be a valid will. Finally, before moving on, as far as testamentary capacity is concerned, you would think that old age, physical disabilities, fatal diseases, substance addiction to drugs, etc., substance would also be something which would be considered as a person not having testamentary capacity. The answer is yes and no, because these are factors which are surely relevant in determining the testamentary capacity, but presence of these factors themselves don't necessarily indicate that you don't have testamentary capacity whatsoever. You can still prove that you have testamentary capacity or that person had testamentary capacity. Uh, yeah. So moving on, basic must-haves in the will. These are the brass tacks which we need to remember. Uh, should a will be handwritten or should it be typed? So a handwritten will is called a holograph will, where the will is in the handwriting of the person who is making it. That is the will maker. Uh, should it be handwritten or typed? It can be either. Doesn't matter. Today, if you have the facility of a typed will, might as well use it. Uh, does it make a difference if it's handwritten or typed? In India, it doesn't make a difference. It's simply it may be better evidence when it comes to litigation if the will is in the handwriting of the person who has made it. Other than that, beyond litigation, there is no relevance of having a handwritten will or a typed will. Um, but the question is a written will mandatory? So the answer is yes. For Hindus, a written will is very much mandatory. Uh, and there is no option whatsoever for Hindus to have a oral will. However, in limited circumstances for other faiths, barring Muslims and Hindus, Christians, Jews, Parsis, etc., can uh, opt for a oral will, but these are only limited people. So it could be a soldier or a seaman who is that is a seafarer who is on duty and has declared orally that he'll be bequeathing XYZ things to XYZ persons. And thereafter, if that person dies, that will or the oral will is valid for 3 months. And thereafter, it becomes invalid automatically. But this facility is only available to Christian, Jews, and Parsis. Hindus and Muslims don't have this facility of oral will. Anyways, having a written will is mandatory. I would always say yes, irrespective of the faith you subscribe to. Sign or thumbprint of the testator either works. I just mentioned that the law requires you to attest it via sign or a mark, and so the testator, that is the will maker, can always have either of these. There is a technical criteria of having a valid will, that is section 63 of Indian Succession Act 1925, which says that you need at least attestation by two witnesses who have seen you sign the will and who have seen that you are in good testamentary capacity at the time of signing this will. And since this word used is seen the testator sign the will, uh, there is an interesting case where the court has observed that a blind person can never act as a witness, reading the law literally. Uh, Clearly mention the beneficiaries and relevant property. I think we have covered this. There is a need for proper documentation and clarity. Should you notarize and register the will? So, neither notarization nor registration are mandatory for a will. But are these good practices? I would say yes, because notarization, the courts have held in multiple cases that notarization is attestation by a judicial officer that that officer has seen you sign the will and you are the person who has signed the will and no one else. That gives you greater credibility in front of the court. Registration of the will is another level of security or validation, where the sub registrar or the government official itself has seen you sign the will. And so, again, it's a good idea as to notarize and register the will. In case it goes to litigation, no one can. It would be difficult for the for the other side to prove that this invalid will was not signed by the person who had made it. The other aspect is select witnesses carefully. Now, we generally ignore these aspects because we just look at the technical realities. So, while technically law requires only two witnesses, you should not have witnesses who are very old, who are financially troubled, because these aspects lead to many complications later on. So, let's say there is a witness who is very old. Uh, at the time of will contest itself, that person may not be alive. So you are left without any witnesses. It doesn't affect as such as to the validity of the will, but had that person been alive, you would have a stronger case. So that is the reason why you would not have a very old person in place. The other point I mentioned was the person whom you have appointed is a financially troubled fellow. If that is the case, then the other party will always go ahead and possibly claim that this is a bought out witness, and we know that from his financial records he's not been earning properly, or he's not in a very good financial condition. And these people have obviously paid him a lot of money just so he could uh, testify in their favor. So again, selection of witnesses is an important aspect, and you need to keep the softer aspects in mind when you are advising the client. Appointment of executors. Now, executors are people who are appointed in a fiduciary capacity via the will itself, where you mention that after my lifetime my properties would go in so and so manner, and Mr. X would be the person who would ensure that these things are taking place after my lifetime. So they are the persons who are executing the will per se, or implementing the will of the dead person per se. And so it is very crucial to have this appointment in place. Although the law does not require you to mandatorily appoint executor, it is a good practice because you save that much time before the court. So executors. Now appointing executors, you must be careful. Similar to the witness thing, you would ensure that you have mentioned the will that if X is not there, then Y would be the executor. If Y is not there, then Z would be the executor. Because while you are writing the will today, you may at the time of your death, maybe that executor is no more, or is incapacitated, or whatsoever could be the reason why he doesn't want to be the executor. The other point is, this person whom you are appointing as executor, or whom your client is appointing as executor, should be a person who is more or less well versed with commercial dealings, and how administration of properties takes place. So for instance, they must be aware of how a bank account should be operated, or how a demat account should be operated, etc. These aspects need to be kept in mind, including real estate. So real estate, changing the name, etc., of the person who owns the property, uh, is something that may be relevant as far as appointing executors are concerned. So basically, people with basic practical knowledge and exposure should be appointed as executors. Doctor certificate, is it mandatory? Again, no, not mandatory, but a good idea to have. In fact, it would be a great idea to have the doctor's certificate, and if possible, the doctor is a good friend, or well known to you, then the doctor could be one of the witnesses attesting the document. And this could also be true for a client, because doctor's certificate would be to say that at the time of making the will, this person is fit and in good health, and I don't see any reason why he should be considered of an unsound mind, etc. So this helps, and if that person is a witness also, and his testimony would also help in case there is a will contest in future. And an interesting question is videotaping the will execution process. So at the time when the will is being signed by the person, or the testator, since we have this a great advantage of technology, we can always whip out our phones and start recording a video of the person executing the will, and then save it in a secure place. When there is a will contest, the court would automatically be apprised of the situation, that via this video recording evidence, it's apparent that the person had testamentary capacity or so. And it's not that this is something which is not tested by the courts. So there have been cases, Delhi High Court, in Delhi District Courts, in Calcutta High Courts, where the courts have relied upon videotape evidence. And in fact, Delhi High Court has also, in one of the cases, very recent cases, commented upon the usefulness of having a video evidence, and in fact also advised government to have video recording in register offices. So there is no point of dispute later on, as to you have a very strong videotape evidence to support your claims, uh, on one side or the other. So this is something which may be considered while advising a client, etc. The last question is probate mandatory for wills in India. What is probate? Probate is just a certificate, sort of a or a document from the courts saying that this will is a genuine will and is a proven will, and so it needs to be executed. That is what a probate means. Now, is the probate mandatory? Because for a probate, you need to approach the court, and the court will, after hearing all the witnesses, after hearing all the persons who have staked the claim against the will determine whether the will is a genuine will or not. And having determined that, it will give you this probate. Uh, the question is probate mandatory? Answer is in India, if the will was executed in Bombay, Madras, or Calcutta, these three places, then probate is mandatory for that will. If the will contains, if a will was, let's say, executed anywhere else in the country, and it pertains to a property which is situated in these three places, that is Bombay, Calcutta, and Madras, then again it is subject to mandatory probate. For all other cases, probate is not mandatory in India. Moving on. Uh, Now we look at some interesting issues pertaining to will. So will is often used in conjunction with other instruments, and it is always interesting to note as to what prevails in case a will conflicts with some other instrument or other tactic or other tool of succession planning. So we'll start by nomination versus will. What would prevail? Nominations would prevail or wills would prevail? So this is a vexed issue which has been going on since years, because the common understanding or the layman understanding is that nomination is equivalent to having a will. And once I have nominated X person and I have nothing else in place, then on upon my death, the particular that bank account or demat account, etc., would go to the nominee, and that is how succession would take place. This is the general understanding. However, technically, this has been considered incorrect by the courts. In fact, very recently in 2016, in Indrani's case, 2016 Supreme Court judgment, it has been considered that the court observed specifically that nomination will only act as a sort of a trustee to the property. The real owners of the property to whom this property must pass is not the nominee, but the person who is entitled to this property, either under the will or under the respective inheritance laws of the person in case there is no will. So nomination versus will, what prevails? As I mentioned, even Supreme Court agrees that wills prevail and nothing else, not nomination. Joint holding versus wills. So let's say you are jointly holding a bank account, and in that, will, you mention in your will, you mention that my bank account would go to XYZ person. Then your joint, instead of your name in the joint bank account, your XYZ person's name would come in to the account. But in case there is no will, then a joint holding would make sense in limited cases. So if you have taken either or survivor, those sort of cases, a joint holding may act as a good succession planning tool as well. But for the purpose of a conflict between joint holding and wills, a will would always prevail. For personal succession laws versus will, this is an interesting comparison. What would prevail? Would the personal law applicable to you prevail, or the will would prevail? So let's say if you're a Hindu, Buddhist, Sikh, or Jain, would the Hindu personal law prevail or the will would prevail? So the law clearly provides that the will would prevail and not your personal law. In fact, even Hindu Succession Act talks about the same thing, Section 2, Section 1 itself, that is applicable only to cases where there is no testamentary succession happening. Then comes Muslim personal law. So Muslim personal law is effectively, as I mentioned earlier, Sharia. Would Sharia prevail, or would your will prevail? So surprisingly, Sharia would prevail, and a will has to be compliant with Sharia. In fact, upon death of the person, death of a Muslim person, if he has made a will, then that will is effective only if all of his beneficiaries, all of his successors under the personal law consent to the will being executed according to that person's wishes. And if they don't, then the will is invalid. And to top it all, this will is only possible for only one third of his total property and not more than one third of the total property. So that is how Muslim law works. But that is an exception to the general rule. So wills won't override the Muslim personal law. What about other faiths or communities, Parsis, Christians, Jews, etc.? Wills would prevail. These are Indian Succession Act 1925 provisions which talk about wills being superseding these personal laws. Everything said and done, practically, if there was something which needed to be done basis this analysis, it is this: you need to have a will. That is one thing. Having said that, your nomination, joint holding, and other ancillary titles, etc., should be in sync with your will. That's all. So everything which you do in terms of your property should be aligned with your will. That is the general advice or the general thumb rule which needs to be followed as far as the succession planning is concerned. Now, what happens in case of cross-border wills? Do things change substantially in case, sorry. Do things substantially undergo a change when you do a will, which involves not only Indian assets but also cross-border assets, so assets in US, UAE, etc. You are a person who is in UAE who has bequeathed Indian properties to their children who are resident in Singapore. So these are the cases which may practically take place. And a general approach of having a single will, noting everything down, all rules of this disposition to the next generation, would not be a very clean method to execute this succession plan. So what we generally advise is we execute separate wills for all different jurisdictions where the assets are located. So let's say you are resident in India and you have assets in UAE, you have assets in US, you have assets in UK, you have assets in India. You execute a separate will for each of these jurisdictions, and the reason is it is easier to comply with the local laws of this particular jurisdiction because, for instance, uh, so it enhances basically clarity and flexibility. For instance, you may have to mandatorily go for probate in UAE. That is the law there. That if it is UAE property and UAE laws are applicable, then probate is mandatory, irrespective of uh, where you are. So that is how UAE would look at the inheritance taking place. And having a will solely focused on UAE assets would help you to avoid that probate process being applied to these other wills and your will being stuck in some other jurisdiction, etc. So that is one thing which would help uh, immensely in case you would have a separate will. Then other thing which you need to be careful about is in amending or revoking your wills. So having said that, you should have separate wills for separate jurisdiction based on your assets. You should be very careful in amending your wills because at the time of amendment you may write that XYZ will is being revoked. You may inadvertently go and by the language that you mentioned in the revocation letter or the new will that you are writing, you may inadvertently go and revoke all the global wills that are in place. So you should be very careful in amending the wills and be very specific with the references. There may also be practical challenges in terms of having multiple jurisdictions, multiple wills in place because for a very basic instance, you can take a case of multiple executors. Would you want local executors? Obviously, a good idea would be to have local executors in place. But then you would have to manage all these four jurisdictions where the assets are located and different executors for different jurisdictions because those executors would be well versed with the practical realities of those jurisdictions. So, bringing these people on the same page, making them realize that this is the intention, this is how things would work during your lifetime itself would be a good idea. But there are practical challenges when you try to go about doing this. So the idea is this would be difficult, but you must plan early on. Drafting is extremely crucial because if in case of even slight ambiguities where your executor is not aligned with your thought processes or in terms of what a particular part of your will means, or how it should be looked at. Uh, there may be a case where you keep going to the court for clarification. So there is no possibility of conflicting provisions is something which you need to ensure. So you have four wheels, none of the wheels should be conflicting with the other wheel in any manner so far as possible. So this is another aspect which needs to be kept in mind. Uh, an interesting question arises: should you cross refer each wheel in the other wheel? The answer is yes. It is always a good practice to have that because it will tie in all the wills together while you have separate documents in place. So it should not so happen that you have this uh, latest will in place and the other documents are not being referred to there and nobody is aware of what are the other documents which you are talking about. So that is something which is important to cross refer each will. In fact, you should also consider having a master document in place where you detail out a summarized version of why you have made so many wills and what all you are trying to achieve in each of these wills and the fact that you have cross referred the will. So a list of intentions of having so many wills, etc., and a summary document which acts as a record of having done your planning in such a manner. This will also hold in good stead uh, sorry, even in administrative issues, as well as for executors to understand, as well as for the courts to understand in case there is a will contest. So these are the best practices you may follow in case the will is a cross-border sort of a will. And finally, you would also want involvement of councils or local experts or advisors across these jurisdictions because they would be obviously the guys would best advise as to what needs to be done in their particular jurisdiction. And as chartered accountants, we are advisors to our clients in India. We should be the people who are coordinating with all these councils and advisors in a manner where the client faces the least amount of pain uh, and has things very clearly presented to him or her in order to take proper decisions. So this is another aspect which needs to be considered in cross-border wills where succession planning is concerned. Friends, moving on to private family trust. So just private family trust is also something which has been in vogue since some amount of time recently, and something very basic which needs to be understood about private family trust is that it is not a one-stop solution. Again, people are we see people uh, coming with queries that it helps you plan for taxes, it helps you do it helps you avoid estate taxes, it helps you avoid future estate taxes which may come up in India. These are not the right reasons for wills for private family trust. And understanding trust, you will realize that they are much more relevant and much more potent than simply planning your taxes. So, what is a trust? Trust is an obligation. So, it is not an entity per se. Trust is simply an arrangement wherein the trustee has the obligation to the settler. Now, who is the settler? So, a settler is the person who owns the asset. That asset the settler transfers to the trustee. The trustee says that okay, I will hold this asset, and the settler says, but you hold this asset in for the benefit of the beneficiary named in this document. That is the entire ethos of the trust arrangement. So the trustee is a person who legally owns the assets, but he cannot enjoy the benefits of those assets. So let's say if these are real estate properties, he cannot enjoy the rent himself. The trustee will always have to pass on the rent to the beneficiaries in accordance with the directions which the settler would have mentioned in the trust deed or the document of trust. This is the broad understanding of what a trust is. And legally, the definition is a bit verbose, but this is what effectively the trust concept is. A trust is an English common law concept and it is seen in common law countries. So countries like India would recognize a trust. Maybe countries like France may not recognize a trust because France, as we know, is a civil law country, not a common law country. What is interesting is how the origin of trust took place. So, what is the genesis of the concept of trust? So, in medieval times, in Britain, there were knights of the king. So, knights were soldiers effectively, and these knights would go to war at times. And when they would go to war, they would leave behind property, assets, etc., which they used to own in hands of trusted persons for them. And so that trusted person was supposed to hold these assets for the benefit of this person, this knight's wife and children. So when this guy would go to war, maybe he loses his life in this war. In that case, he has already planned for how the wife and children would be taken care of by virtue of having a trusted third party own the assets and use them for the benefit of these relatives of his. So that is how the concept of trust came about. Interestingly, there is no concept of trust or a concept akin to trust in Hindu civilization. The most most proximate or the closest concept to trust which Hindu civilization used to have is the concept of family. That is a Hindu undivided family as we refer today. But the family construct itself was such that it used to replicate more or less a trust sort of a concept where the head of the family would be the person who would take the decisions for the property, like the trustee, and it would always be for the benefit of all the family members. So that is how a trust origin, and I think this gives you a greater insight as to how a trust works per se. Now, coming to the slide itself, trusts are arrangements supported by the force of law, right? So these are governed by, in India, Indian Trust Act 1882 governs private family trust or a private trust in general, and they are governed, supported by the force of law. They are not legal persons, so they are not entities. You would not be able to sue a trust or be sued by a trust, or the trust cannot own assets in its own name. Uh, but these are arrangements, and these are look through arrangements. So the legal owner would be the trustee, and the beneficiaries would be the person who would get the benefit from the trust. The parties involved, as I said, settler, that is the wealth owner who had transferred the property to the trust. Trustees are the persons who are obligated to hold the property for the benefit of the beneficiaries, and beneficiaries are the persons who simply enjoy these benefits. Trust can be revocable or irrevocable. So the settler can say that I am transferring XYZ property to the trustee, and the trustee will hold it for the benefit of the beneficiaries. But I can, at any given point of time, say that I no more want this arrangement to be in place, and the trust property would revert back to me as the sole owner. This would be a revocable trust. It is possible in India. An irrevocable trust is a trust where the settler has said that this property goes to the trustee and it will remain with the trustee, and I will in no case be able to revert this property back to myself directly or indirectly. This would be an irrevocable trust. The taxation differs widely, but there are hardly any consequences which you would see happening. And so beyond taxes, I think commercially these are immensely flexible tools which you would be using for succession planning of very large number of cases, maybe not all, but a very large number of cases. And why? And the reason why is, number one, trust deed governs how the trustees operate. So you have a document which will tell the persons you are entrusting this property to that, see, you have to administer this property, you have to deal with this property in XYZ manner. And if you deviate from this, I have imposed XYZ penalty on you under this trust. And the law also prescribes that penalty. So maybe you would say that if you go against this trust deed, then the trustee would be removed with immediate effect. And on top of that, the trust law would also have some penalty or liability in case of a breach of trust on the trustee. So that's why a trust deed would also not only govern the disposition of the property would also govern the dealing and governance of the property. So a trust deed governs how the trustees would operate. Uh, so there is a full flexibility in defining these roles as well. The trust law does not define the role in great detail. It leaves it to the settler to make this a defining instrument. And there is a great amount of flexibility, as mentioned. Assets settled in a trust enjoy significant protection from matrimonial and creditor claims. So these are ring-fenced assets, as we call it. So in case you have transferred your assets to a trust, it ceases to be your own property, subject to there being no revocability. So in an irrevocable trust, and so in an irrevocable trust, if you have transferred the assets, and there is some creditor claiming that I have security over your asset, over your personal assets, so I can also claim the trust asset. That is not true, because the trust asset is not effectively owned by the person himself. It is owned in the trust by the trustees. The third point, which is very interesting, is no probate is required in trust, irrespective of whether it is in Bombay, Calcutta, or Madras, which I mentioned earlier for wills. These are the reason. This is one of the reasons which makes the trust instrument lucrative, because probate is a very tedious process since it involves courts, and courts take their own sweet time to get back on probate matters, because there are other matters which are pending, which are beyond civil. So there will be criminal matters, etc. And so a probate is always a tedious measure, and family trust would avoid would avoid making you go to the probate courts. Registration required only on settlement of immovable property. Otherwise, registration is also not required for private family trust. You can have movable properties in this private family trust, like liquid funds, shares, etc., and you would not be required to go for registration. Applicability immediately on execution. So trust would come into effect immediately upon execution of the trust, and you don't need to die like you would have to do for a will. If for a will to come into effect, that person has to die. For a trust, that is not the case. And this is another reason which is very important, which I'll take up in subsequent slides, as to why this feature of a trust is very important. Not to give much importance to potential Indian estate tax, but so people say that there is a potential that an Indian estate tax may kick in the future. So today there is no estate tax, as we all know, but there used to be one till 1985, which was eliminated. Now, there is a constant fear every year that the new government would, or any government, ruling government would try to impose an additional Indian estate tax on the citizens. But since the last 40 odd years, that has not happened. Uh, and so, while you may consider a potential Indian estate tax while creating a private family trust, but you don't compromise much while doing so, compromise on the succession aspect much. So that is one thing which must be kept in mind. Now, private family trust, having understood the concepts and the broad outlines around it, uh, why would you prefer a private family trust? So, what are the features which would attract you to using a private family trust? Uh, Private family trusts are preferred tools for passing on control and ownership of family businesses, and the reason is this wise. There is a consolidation of control which happens. Now, what is consolidation of control? So let's say you pass on the property through will, and this also covers multi-generational planning, the last point in this slide, consolidation of control and multi-generational planning without fragmentation of ownership. I'll take these two together. So consider a case where you pass on your property, your shares in your business to a will. Currently, you own 100% and you have two children, two sons, both of them are in business. You provide them 50-50 shares. If you are a, in a general case, you would assume that would happen. And so 50% after your death would be owned by son A and 50% by son B. Now they would be able to take decisions, but only together. They would only be able to take unanimous decisions, because none of them have majority today. So let's say there is a son A is better at finances, son B is better at execution, etc. Or technicalities of the business. uh, you would want that son A has the power to take those decisions which he is good at, and son B would have the power to take those decisions he is good at. This is not possible as far as a will is concerned. But maybe you could do this in a trust, and we'll see how soon. In fact, I'll take this one step forward to make it easier. Son A is not interested in business and has no inclination towards the business. He just wants to do a job somewhere else. And son B is fully into the business and wants to grow the business. And still, you would like the benefits to go 50-50 because both of them are your children, nothing against them. So, the son who is in business would effectively lose out control to a person who is not at all interested or concerned with the business, and he would have to take all the decisions with this other fellow. Now, this can be easily solved by having a trust. You settle all the 100% shares in this trust and make the son B, who was in the business, as a trustee, and son A and B both as beneficiaries 50-50. What will happen is son B will control 100% stake. He'll take all the voting decisions, etc., pertaining to the business, which is so much running and growing into. But son A, who is not concerned with the business at all, will only enjoy the benefits of the business. And this can be structured in a very different way. It can be structured to make it more logical, more suitable. But the idea is, while in the earlier case, the control used to split between the two brothers, and the person deserving the control had to give up the control, and the person not deserving the control got the control with the benefits. Had it been the other way around, 100% went to the son B just because he's interested in business. The other son who is not interested in business but should have been given some benefit for his, you know, wealth creation was not given. So a trust effectively addresses that. And if you think about further wills, so let's say 50-50 through wills between son A and B, then son A writes another will between his two or three children, and it goes 25-25. Then it goes further and further and further. And before you know it, there are eight people owning 12.5% of the company. And no one has control effectively to, so to speak. And so this is what I would refer to as fragmentation of ownership of the business. But in case of a trust, that can be avoided because the control would be consolidated and all shares would lie in the same trust, and the family would speak as one as far as the trust is concerned. There is separation of control and economic benefits. So as I said, the control would be in hands of the trustee. He would be the person who would be dealing with the property, etc. And the economic benefits would be spread across all the family members who would be the beneficiaries. And the trustee would be only possibly one or two of the family members who would be owning and running the business. But the benefits would flow to the entire family. So this is how trust helps immensely in planning your succession. You can also add protection for some family members. So let's say the proprietor's wife is a homemaker, which is a noble thing, but unfortunately she is not well versed with finances or may not have finance or business acumen. Uh, so what he can do is provide for an advisory board sort of a structure within the trust itself, or at least provide that so much amount of money will be distributed every year to this to his spouse, and so on. So these things are possible. It is also possible to provide for protection of specially abled beneficiaries, etc. So people who are specially abled, who are minors, are not able to take care of themselves for good reasons, and so you could have a trust arrangement for them to take care of them financially and otherwise. Remember that trust is not a mummified manuscript. That is, in other words, not a rigid document. You can always have powers of amendments within the trust itself. So you can provide that. Trustees can amend the trust deed to this extent. Should you give such powers? The answer is yes, you should, because not having amendment powers or not having flexibility could lead to very harsh and adverse circumstances and may defeat the purpose of having a succession plan in place, uh, which we have already gone through earlier. So I'll not touch upon that again. The last point is incapacity planning, and incapacity planning, when I say, is at the same point as the earlier example which I took of the Karnataka High Court decision, where the person who was in a comatose state his wife suffered a lot because of the lack of incapacity planning. Now, in a trust, you can have incapacity planning by saying simply that today I am the trustee. In case of my incapacity, XYZ person would take over as a trustee and the trust assets would stay operational. So that is how a trust can also help in incapacity planning. Uh, and this is the reason why the feature which I highlighted earlier of applicable immediately on execution is very important as compared to a will when you look at trust. Now, legal essentials, I'll just brief you on the legal essentials. Arbitration is not possible in trust because trust related matters because beneficiaries are not a part of the trust. But you can have similar mechanisms inbuilt into the trust deed, which talk about dispute resolution. Some essential aspects to consider are security laws and FEMA law. So there is a minimum promoter contribution requirement. There is an offer for sale requirement, layering of trust. So trust and subtrust structure may not be permitted, etc. In case of securities laws. So these needs to be considered very crucially. The other part is rule against perpetuity. So rule against perpetuity means that trust cannot effectively mean that it will last forever. There is no perpetual succession possible. It has to have a definite end date. So that is one thing which needs to be kept in mind. Rule against perpetuity while drafting a trust deed. And the provisions of Indian Trust Act must be considered. For instance, under Section 20 of the Indian Trust Act, you would see that only limited investments are possible. And in order to ensure that the trust property can be invested freely by the trustee, you should mention that Section 20 of the Indian Trust Act is overridden by by virtue of this trust deed, and the trustee can invest in so and so an exhaustive list of assets which you can mention in the trust deed. And this is also permitted by the law itself. So Section 20 says unless otherwise mentioned in the instrument of trust. So that's how you can just plan around the law itself. And consideration basically of Indian Trust Act is essential. A practical essentials important to provide for trustee succession, especially if only minor is a beneficiary. Then it is important that you say that today X is trustee. In case of his death or incapacity, Y will be trustee. In case of his death or incapacity, Z will be trustee, and so on. Uh, because this would ensure the continuity beyond generations to come. Charity through family trust, is it a good idea? Well, you can always do that, but you should not lump. It is advisable not to lump your charitable aspirations with your core assets like shares in your business, etc. Because there are lingering risks of charity commissioners reaching to your doorstep just in order to harass you or something. Harass you in the sense that charity commissioner does have a legal right in case the object of your trust deed contains a, a provision that it is for the purpose of charity or charitable purpose as well. Even if that is one of the purpose, the charity commissioner could very well step in and say that, hey, you go ahead and register this trust as a public trust. And that's damaging because a lot of compliances would go in and the document would not remain confidential. So to avoid all these risks, it's a better idea to have a separate trust and make those contributions from that trust. It is also possible to incorporate family governance in the trust, and this is legally binding. So you can mention between the trustees that these decisions will be taken in X manner. These decisions. So let's say there is some amount of property lying in the trust. You could say that the decision to sell this property would be with X person, but he cannot exercise it without taking consent from Y person. So that's something which you can provide. And governance can be dealt with properly. You can also have disclosure mechanisms. So let's say X person is running the entire business, uh, he would have the obligation to always report every quarter as to what he has been doing with the business to all the beneficiaries of the trust. So that is also possible. The listed company controlling stake as well as portfolio investments held through the same trust is a good idea. The idea may not be that good because let's say there is for some reason SEBI questions your uh, you know uh, decisions for some portfolio investment, and the regulatory oversight would come to all the trust assets including your listed company stake which you are controlling. So you would not want that. or the other way around, where portfolio investments are stuck under SEBI scrutiny. So these are some things which can be considered. In case possible to avoid, you may avoid. Preferably give successors at least limited powers to amend the trust deed. As I mentioned earlier, and it has been a constant refrain, you should incorporate flexibility in your trust deed. Careful thought to be given to some important aspects of the provisions, like adding, removing beneficiaries or trustees. Who has these powers? Uh, can the next generation have the power to add, remove beneficiaries? Can they remove each other as trustees, etc.? uh, Amendment of trust deed. Who can amend the trust deed? How can the trust deed be amended? How would the decision for investing, selling, distributing property be taken under the trust? Who would be the excluded person? So on committing XYZ offense, you may be removed from the trust. On divorce, the spouse could be removed from the trust. These aspects need to be given careful thought while developing a trust deed. And friends, finally, I think I'm overshooting my time by some minutes, but I'll just cover this quickly. So, a family constitution is not a binding document, but what a family constitution does it's a broad framework within which the code of conduct of a family would be mentioned by the ancestors or the head family members who are planning for the future. One great example of this family constitution, use of this family constitution, is the Mitsui family of Japan. So they are Japanese family, and their family constitution was established in 1722, and is still in place to our surprise. Uh, it contains points of how to it has code of conduct for the family itself. It talks about cases of marriage, business management, debt, how would the family members incur debt, etc. So, and Mitsui family, by the way, is a family which owns most of the Japan today. uh, they have this constitution since 1722. In fact, uh, I have been talking about having flexibility in the succession plan since the time I started on the presentation. Mitsui family is the biggest example of having flexibility, because what they did is in 1945, since 1722, they had the same constitution. In 1945, when World War II happened, they revoked the entire constitution, they liquidated it or dissolved it, and they put in place a new constitution for the family, which redefined everything, because Japan had changed substantially due to the influence of 1945 bombings and the World War itself. And so, family constitutions, as I said, are potent tools, but they are only as good as the persons who are bound by it, or who are supposed to be following it, uh, because they are not legally binding entirely. Now, how are they relevant and what do they contain? So, as I mentioned, this is planning for family governance and family business continuity. It contains a code of conduct, decision making processes, family values, and guiding principles. It is broadly like a policy document. So, just like FEMA has FDI policy, and the FDI policy is then enshrined or codified by virtue of the FEMA rules and regulations, like non debt instrument regulation. Similarly, a family constitution would be a policy document which would at least give you an idea of how to interpret the other binding documents, uh, like trust deeds, shareholders agreement between the members of the families, etc. So those documents can be separately executed by the family in order to bind themselves legally, between create rights between themselves. But a family constitution would be a overall guiding policy document sort of a thing, which would be held dear to the family itself. Now, uh, as I mentioned, it's not completely binding itself, and needs support of other instruments. There are public instances of this. The GMR group has a family constitution in place. Dalmia Cement has a family constitution in place. The Dabar group, that is Burman family, has one. Godrej family also has one. And these are, as I mentioned, potent documents. I think that is all I would say is uh, for planned for for today's session, succession planning. But I would end by saying it is always relevant uh, to remember that what we have done for ourselves dies with us. What we have done for others and the world remains and is immortal. So please ensure that you put in place a plan, because what you will do for others, that is the succession planning, will always remain and it is immortal. So that's all I'll say. And thank you for a patient hearing to every one of you. And thank you for the opportunity to present this today.
We have a few questions, just one or two. It's from Venkateshwaran. He has asked, will is superior to law except Muslims? Is it as per constitution, law, or as per Supreme Court judgment?
No, so Indian Succession Act, if you look at Indian Succession Act 1925, you look at the relevant provisions on testamentary succession, it is, I think, part 2 of Indian Succession Act, where they have mentioned the applicability. It says that it does not apply on Muslims, certain provisions, and most of the provisions you will see are not applicable on Muslims themselves. So this is how it comes from. Constitution has nothing to do with this aspect, but it comes from the Indian Succession Act itself. So it actually mentions that these provisions related to wills are not relevant or not applicable to Muslims. That is how it's coming.
These were the only questions. So we can wind up. Thank you, Bakshiji, for an insightful and enriching session. On behalf of Committee on Commercial Laws, Economic Advisory and NPO Committee of ICA, I extend our heartfelt gratitude to you for sharing your deep expertise on the topic given, succession planning essentials, tools and techniques. Your clarity in explaining complex structure, your practical approach to wills, trust, and promoter family dynamics, and your emphasis on FEMA considerations have added immense value in today's discussion. We thank you once again for your time, your insight, and generosity in sharing your knowledge with ICI community. Thank you so much.